Okay, hold on.
I'm sorry.
No, it's okay. I'm not worried right now. Let me just say this. I won't worry at this moment about November, but you put in your motion that you were going to get October paid, right?
Yes.
Okay.
Your Honor.
Hello, what's your name?
Brianna Jones.
Okay, you need to take your hands out of your face if you would. Thank you. All right, is this your motion to set aside?
Yes.
All right, what's your basis on setting that aside?
I'm sorry.
Pardon?
I didn't hear you.
What's the basis of which you want the judgment set aside?
Oh, because I had missed the first court date because the lady, I had made a payment for September and she told me don't come to the court date if I had made.
She who told you that?
Lady in the office at Arbor One Apartment.
Okay, let me ask this. What's her current balance?
Current balance, $2,464.94. Your Honor, the motion states that she's going to pay her balance by October 31st, which she has not done.
No, I wasn't able to. My car had broke down again, but I can make a payment of $900 that's on the judgment on Monday. That's most.
Okay, so here's the problem. The problem is that the judgment was from October. You don't have October paid, and now I've got November.
Yes, and I have started an application with I don't know what the program is called for them to help me pay my rent.
Hawk?
Yes.
You got an application with Hawk?
Well, I started. Yeah, I got an appointment on Monday.
Young lady, did you have an appointment with Hawk or no?
I have an appointment on Monday. I had talked to them already, but then I had to get it.
You have an appointment this Monday?
Yes.
Do you mind if I get a confirmation of that? Amy, do you know?
She has an appointment coming up on the 18th.
You don't have an appointment till the 18th.
That's not this Monday.
Well, that's not this Monday, but it's next Monday. But in the interim, how much has she paid since October 11th, Ms. Luckoff?
Give me 1 second, Your Honor. The last payment made was October 1st. Nothing has been paid since October 1st.
I
I
asked
don't
for
a basis to set aside the judgment at this point. She's not presented a meritorious defense. If we give her the credit for what she's saying, why she didn't come to court the first time.
Right, but I was a bit confused because she said she paid $800.
No, I paid because the first time this was ever brought out was from September, and I paid September's rent, and she told me do not come to the court date because I made a payment. Then it dragged over into October.
Your Honor, they never.
The first hearing date was October 11th.
Yes, but that was for September's rent.
No, it includes October rent at that point.
Okay.
I know that what the complaint may have said, but your October rent would come due. That's why there was $1,194.
Right. I can making a payment of $900 on Monday for the.
Okay, so young lady, here's my problem. My problem is why don't you at least have the $1,194, which would be your October rent?
Because I had lost my job, my car broke down, I had to use some of my rent money to get my car fixed. I wasn't able to pay.
No, I hear you, but you see the problem? Because now I'm sitting here at a hearing in November. November's rent is due.
You're right.
That's what the problem is. And then even if I take the benefit of the doubt of what you tell me you can do, right? It doesn't even pay through October. And then I've got November.
Right.
Okay, look. What can you come up with between now and the 15th? You said you had 900.
Yes. That's for October, and I was expecting the people
Hold on.
to help me with November's rent.
Okay, hold on.
I'm sorry.
No, it's okay. I'm not worried right now. Let me just say this. I won't worry at this moment about November, but you put in your motion that you were going to get October paid, right?
Yes.
Okay. between, you got 900 right now, right?
Yes.
Okay. To get, is her rent about 1,200, Ms. Lacoff?
Yes.
Is that about right?
Let me check.
Because I had 1194 on the judgment, and then it sounded like which
For
was really
rent,
like
I mean, the
1,200.
base, I'm sorry.
Go ahead.
It's 1065 for the base, and there's water, trash, gas. So it's 11, yeah, it's about 1140.
Okay, so about 1,200, whatever.
Yeah.
Okay, but you got 1194 because you got court costs in there, you got all that kind of stuff in there.
Correct.
All right, look, young lady, you got a meeting with Hawk on the 18th, right?
Yeah.
There's some funding coming in that may be able to cover you for November, even if it went into December. So just listen. But what has to be paid is this judgment has to be
Yes.
paid.
So if I pay the judgment on Monday,
Well, how much can you pay on Monday?
well,
You gotta
I'm gonna
tell-
have guaranteed 900 on Monday, but I can ask to borrow the what $200 I'm owed
Well, you need $1,200.
for the judgment.
Well, I need $1,200 by Monday.
Okay.
Can you get that paid?
Yes, I can. Yes,
Can you?
I can try. Yes, I can ask to borrow on Monday.
Oh,
I mean, I can
look,
ask to borrow for Monday. I know I could come up with 1,000, but I'm not sure. I'm not sure about the other 200.
Here's what I'm going to tell you. This is the only way we're going to salvage it. And I shouldn't give you this, and I'm doing this over the objection of plaintiff, okay? Because it seems to me you found yourself in a spot you don't even know what to do to get yourself out right now, right?
Yes.
So I'm going to give you a chance to try to get it done.
Okay.
And over the objection of plaintiff, I'm going to adjourn you out 1 week on your motion to the 15th at 12 p.m. You need to pay the $1,200. I'll make it by the 13th, which is because Monday's a holiday, and I'll give you a day. So that's that Wednesday. If it gets paid to them on the 14th, I'm not talking about it anymore.
Okay.
You need to get it there by the 13th. All right? Then you've got an appointment at least coming up on the 18th with Hawk. And let's see then if we can get your November paid and salvage your tenancy. You follow me?
Yes. Thank you.
And so I'll adjourn the motion out to that date at that time. Get that paid, young lady. If it's not paid, I'm not going to be listening to anything.
Okay. Thank you.
Courtroom hearings like this often seem simple at first glance. Unpaid rent, a missed court date, a request to undo a judgment. But beneath that surface, something far more complex is unfolding. This is not just a legal procedure. It's a collision between responsibility and reality, between deadlines and desperation, between what the law demands and what life allows. From the very beginning, the atmosphere is controlled, not cold. The judge is calm, focused, measured. That tells us something important. This courtroom is not driven by impulse or anger. It isn't here to punish for the sake of punishment. It is here to verify one thing only: whether promises are backed by action. The defendant, Anana Jones, steps forward already at a disadvantage. There is an active judgment against her. There is unpaid rent. And there is a motion asking the court to erase a decision that has already been made. Legally, that request carries weight and burden, because explanation alone is not enough. The law requires proof, a meritorious defense, something solid enough to justify turning back time. This is where the tension begins. Gone is any trace of confidence. Her posture shifts. Her voice softens. She explains that she missed her first court date because she was told not to attend. According to her, an employee at the apartment complex advised her that since a payment had been made for September, court wasn't necessary. The judge does not dismiss this claim. He listens. He asks questions. He allows her to speak. But listening does not mean agreeing. The courtroom quickly pivots to what truly matters. Numbers, dates, records. The judge asks for the current balance. The answer is precise. Over $2,400. That number carries no emotion, no sympathy, no judgment. It is simply fact. And from that moment on, facts take control of the room. The landlord's representative confirms what the records show. No payments since October 1st. No partial payments. No effort to reduce the balance. Even if the explanation for missing court were accepted, It does not erase what happened afterward. This is where many defendants misunderstand the system. They believe hardship explains everything, that intent can replace action, that wanting to pay is the same as paying. But courts do not operate on intention. They operate on performance. The judge makes this unmistakably clear. October rent was due. November rent has now passed. And regardless of circumstance, the math does not change. Judgments do not appear randomly. They are built, missed obligation by missed obligation. What makes this hearing compelling isn't confrontation. It's contrast. On one side, a woman describing real struggles, job loss, car repairs, unexpected expenses. On the other, a court that has heard these same stories hundreds of times. Not because people are dishonest, but because hardship is common, and systems still require structure. The judge's questions grow sharper, not harsher. Why wasn't October rent paid, even partially? The answer circles back to hardship. Money redirected. Employment lost. Options limited. And for a moment the room feels heavy. Because these are not outrageous excuses. They are realities millions face. Then the judge reframes the issue. The court isn't only looking backward. It's looking forward. It's November. Another rent cycle has passed. Even if October were partially addressed now, November remains unpaid. Optimistic promises still fall short of full responsibility. This is the problem the judge keeps returning to. The gap between hope and obligation. The defendant mentions applying for housing assistance. Again, the judge doesn't dismiss it. He verifies. He asks for dates. He checks timelines. And when it becomes clear that help is not immediate, another reality sets in. Assistance may come, but not fast enough. Legally, the court could end the discussion right here. The plaintiff objects. The legal standard has not been met. The motion could be denied outright. But it isn't. Instead, the judge pauses. And then something unusual happens. He speaks with rare honesty. He acknowledges that the defendant appears overwhelmed. That she may not fully understand how to escape the situation she's in. And in that acknowledgement, the court extends something rare. One final opportunity. Not mercy without limits, but mercy tied directly to accountability. The judge lays out the path forward with absolute clarity. The judgment, roughly $1,200, must be paid. Not eventually, not partially, not hypothetically, fully, by a specific deadline. And he makes something else clear. This opportunity is granted over the objection of the plaintiff. That matters. Because this is not standard procedure. This is judicial discretion, exercised carefully, deliberately, and conditionally. Then the tone shifts. Negotiation ends. Ultimatum begins. The defendant says she can guarantee $900. The judge responds plainly. $900 is not enough. Partial payment does nothing. It does not reopen the case. It does not delay enforcement. It does not buy time. I'll try is not an answer the court can accept. The judge pushes for certainty. Can the money be obtained? Can it be paid? Can the obligation be met fully? This moment captures the essence of courtroom accountability. Compassion exists, but it has limits. This is not punishment for being poor. This is enforcement of responsibility within the law. Deadlines matter. Obligations matter. Judges are not villains for enforcing consequences. They are not heartless for demanding compliance. They are fulfilling the role entrusted to them, balancing human struggle against legal order. And when that balance tips, the outcome is not personal. It is procedural. Now the future turns on one thing alone. Not words. Not promises. Not explanations. Only action.